the San Francisco to San Jose segment preclude compliance with Section 2704.09C, operating headway timeframes, or 2704.09B, total trip timeframes. So this gets back to the argument I was making earlier, that the blended system is on, basically, as it's currently planned, as it's being proposed, it doesn't fit with 2704.09. When you look at the headway requirement of 2704.09, it says it's got to be, the minimum headway has to be no more than 5 minutes. When you look at the studies that have been done about the blended system, they say the maximum you can run on the blended system is 10 trains an hour. Now, bear in mind also that under 2704.09, when it's talking about headway, this is about a high-speed rail system. So the presumption is that this is high-speed rail headway, not conventional rail headway, it's high-speed rail headway. It's saying you have to be able to run high-speed rail trains within 5 minutes of each other. And the reason for that is because the legislature was very much aware, even in 2008, that the ridership was going to be very dependent on headway. That in order to get the maximum ridership, you had to be able to, when needed, run a lot of trains. So if you're talking about, let's say, for example, people wanting to get from LA to San Francisco that same day, to be able to go to a meeting in the afternoon, and there are probably going to be a lot of them, if the ridership model is correct, you're going to have to run a lot of trains in the morning rush hour. You're going to be running a lot of trains to get people there when they want to be there in the afternoon. And that may require you running trains every 10 minutes, maybe even every 7 minutes, maybe even every 5 minutes. But you can't be constrained to running a train every 15 minutes, because that's not going to work. You've limited the system capacity in a way that's a problem. And that's why the legislature set that 5-minute headway. It says we want to be able to run trains as close together as 5 minutes if we need to. We don't want to end up being constrained and saying, oh my God, we built a system that isn't going to be able to handle the capacity that we want to have. Even if you said, well, you know, maybe they're, even though they don't mention conventional trail, maybe they were thinking about some sections where there might be shared track with conventional rail. And so you still, you know, you're going to have 5-minute headway. The blend system can't get a 5-minute headway. Even with the onboard PTC, positive train control system, the CPOS system that Caltrain has put in. And assuming that's installed and fully operational, they still can't get closer together than 6 minutes. Now the authority says, oh, but there's a statement there about 3 minutes. Well, that's if you're running 2 successive trains following exactly the same routing, stopping exactly the same stations. And yes, if you were to run every single train stopping exactly the same stations, you could run them at 3-minute intervals. But that's not the blended system. The blended system includes high-speed rail trains, includes Caltrain express trains, includes Caltrain local trains. They're all running different station schedules. They all have to be coordinated. And what the study that Caltrain did says is maximum is 10 trains an hour for that system. Now, it is possible, maybe there'll be improvements, maybe there'll be some other thing will come along that will allow them to meet that, but not now. And under the snapshot approach, you can't do it. You know, if they want to come back later when they've improved things and say, oh, we can now run 12 trains an hour, then they're welcome to come back in and say, we can now do it, but not now. The same goes for the trip time.
Wait a minute, let's come back.
Yeah.
Let me give Ms. O'Brady a chance to respond to the headway issue.
Your Honor, the record contains evidence that, substantial evidence that the authority can make the headway time in compliance with the Bond Act. The LTK report that's in the record says that you can run trains at 3-minute intervals. The statute says that the system shall be designed to achieve that characteristic, and it achieves it. The fact that there may be slots that are at least initially slotted for other trains doesn't change that. And I would just note that the Bond Act refers to headway between trains and not high-speed trains. And if you look back at the EIR that actually contemplated sharing of track, where dedicated track isn't feasible, you can understand why they would say that.
What if the court were to find that the headway requirement couldn't be met with a blended system? What happens then?
I think that the court would still have to conclude that because the blended system is the product of the legislature and an appropriate action of the legislature, and no one has suggested that there's anything that the authority has done that has made it worse. They're just saying the blended system dictates it, that it is permitted under .06, and it is also within their power to amend a bond act as long as it doesn't affect the repeal. And this does not affect a repeal of the bond act.
So the specific 5-minute headway requirement would be, in effect, modified by the general language of 06?
It could be. But remember, the system characteristics can account for 3 minutes between trains. At some future time, there may be running all high-speed trains down the corridor. And BART may be providing commuter traffic to San Jose. The system is designed to meet the requirements.
Your Honor, the system includes how it operates. The system is not some abstract thing where you can say, we're going to run 2 trains and they're always going to run exactly the same distance and we're always going to stop at the same stations. That's not the system that the authority is building. And the system, as it's being designed, is running a mixture of Caltrain trains and high-speed rail trains. And it's running local Caltrain trains and it's running express Caltrain trains. That's the system.
But isn't the court going to interpret to be designed is essentially capable of? Isn't that sort of a reasonable way of looking at that?
The system is designed to be capable of. And designing the system means not just laying the track, but understanding what's going to run on those tracks. I mean, yeah, if you could run Hyperloop on the tracks, you could meet all of the requirements easily.
But that's not our system.
No, it's not our system. But the point is it could be, when you say this is a capability, well, maybe we could put in Hyperloop on the same right-of-way, and then we could call it, we met everything. That's something in the future.
Hold on. I am basically focusing on to be designed. And what does to be designed mean?
Well, it doesn't say to be designed. It says the system shall be designed to meet the following criteria. And so when you're designing the system, you're not designing just some abstract thing where 2 trains are going to run exactly in parallel, stopping at all the same stations. The design of the system includes what is it going to carry. And right now, the system that has been designed is a system that carries Caltrain local, Caltrain express, and high-speed rail trains on the same 2 tracks. And what the evidence on the record shows is that system cannot meet the 5-minute headway requirement.
Total trip time?
So on trip time, and let me go to one of the other slides here. So this slide is from the memo to Jeff Morales and Frank Vaca, from the people who are doing the project management team, saying this is our analysis of trip time on the peninsula. And it's page
22899.
Okay, 22899 in the record. And what, looking specifically at the Phase 2 blended system, and you're looking at San Francisco to San Jose, what you see is a 32-minute trip time. And that's 110 miles an hour, which is what the system right now is designed for, 110 miles an hour. That's 32 minutes, and that's not going to the Transbay Terminal. That's going to 4th and King, the Caltrain station, which is not a station that's approved in either the 2005 EIR, the 2008 EIR, nor is that mentioned in Prop 1A. The only station in San Francisco that's mentioned in Prop 1A is the Transbay Terminal. It's the only station that is authorized in the 2005 EIR. It's the only station that's authorized in the 2008 and it's going to be an additional 3 minutes, given the constraints on taking that admittedly a rather short distance, but the way the line's got to run under the streets of San Francisco, it's 3 minutes added on. So we're not even talking 32 minutes, we're talking 35 minutes. That's not 30 minutes. And yes, maybe at some later time they can come up with something better, but right now, they don't need it.
And Ms. O'Grady, let's talk about the Trans-Bay Station versus the Fort McKean Station, because it does seem that everything is referring to the Trans-Bay Station, and yet you seem to go with the other station.
Well, the actual section in 2704.09 does not call out the Trans-Bay Transit
Understood.
Center. And this just goes to the brightness of this whole issue. They haven't finalized plans to get to Trans-Bay. They're going to initially be going to Fort McKean. Eventually, obviously, they're going to get to the Trans-Bay Transit Center, but determining exactly how that's going to happen, it's too early to tell.
Well, the question
but it's only
hold on,
a mile.
it isn't the question whether or not the blended system can achieve the 30-minute total trip time. That's the question. And whether or not there's substantial evidence before the authority to establish that. And we're talking about total trip time as essentially to Trans-Bay would appear from everything that's in the record. I'm not sure how you get to Fort McKean.
The analysis that was done prior to the adoption of the blended system, the LTK study that was done for the legislature, used Fort McKean because the high-speed rail is going to at least initially have a station there. And it doesn't say that it has to be from a particular station, but we believe that the record as a whole amply supports the fact that the authority is on track to meet that travel time.
Well, here's the first question. What do you think the San Francisco terminus is for the 30-minute time frame, pursuant to the requirements of the Prop 1?
I don't think there's a specific travel time requirement to the Trans-Bay Transit Center. It's from San Francisco.
Now, what I'm asking is, what's the terminus for San Francisco? Is it Fort McKean? Is it Trans-Bay? What is it?
There's going to be a station at Fort McKean.
I understand. But I'm asking simply, when measuring the 30-minute time frame, what are we using as our 2 points? And specifically, what are we using as our San Francisco point?
The authority is using has been using the Fort McKean.
And what's the justification for that in the statute or in the record?
That's where the station is going to be, at least initially.
But is that consistent with what Prop 1 requires? That's what I'm trying to understand.
I believe it is, Your Honor, because it doesn't call out any particular location in San Francisco for that travel time. And it's only a mile. It's going to be an insignificant difference in time on a stretch of track that hasn't even been completely designed yet. The authority ought to be given the chance to come up with their final plan and present it and have it judged, as the Court of Appeals said, on what they actually intend to construct with Prop 1A bond funds.
But isn't part of the question whether or not the total trip time can be met? And if, in fact, Mr. Claxton is correct with regards to 32 minutes between 2 points that are used for measuring that time frame, and one of those 2 points is actually incorrect and it should be actually further, doesn't that raise a substantial evidence question with regard to whether or not the blended system can meet the 30-minute total trip time?
I don't believe so, Your Honor, because again, every bit of slowness on the peninsula is a direct result of the fact that the legislature is requiring the blended system. And so you have to look at their ability to do that. And they had actually, they made that determination based on a feasibility study by LTK, which actually, for purposes of that study, had even a longer trip time. And they decided that it was still appropriate because the blended system was going to have many benefits, including reducing disruption in the communities and saving money.
But is your argument then that the legislature's requirement for a blended system, even if it can't meet a 30-minute time frame, is okay?
Yes. But we believe, but the authority is planning to meet that timeframe. But if it can't, yes.
I guess I have to fundamentally disagree, because the 30-minute trip time is right there in plain black and white. It could hardly be any clearer that the legislature and the voters were mandating a 30-minute trip time maximum between San Jose and San Francisco. And in terms of San Francisco, 2704.04A specifically says that it's going to be a high-speed train system that connects the San Francisco Transbay Terminal to Los Angeles Union Station. So it's basically saying, this is what we're building. We're building a system that starts at the Transbay Terminal and goes to Union Station in Los Angeles. If you're talking about time between San Francisco and San Jose, it's got to be to where it starts, this Transbay Terminal. You can't say, oh, we're going to build a station right at the border between San Francisco and San Mateo County, and that's still technically in San Francisco, so it works. That's not what the voters understood. That's not what the voters intended. And to say that the legislature can essentially disregard a simple and plain English requirement in the bond measure it's basically what the Board of Supervisors were trying to do in O'Farrell, and you can't do it. It violates the California Constitution.
Anything further, Ms. Brady?
I would just make 2 points. The plain language of the statute does not require that you go to the Transbay Terminal, and the appellate court decision in the prior proceedings in this case was went into considerable discussion when determining that their claims were then unright and still are, that in big infrastructure projects there is leeway, that they actually say there are many cases in which the courts have broadly construed the purpose of the relevant bond act to allow projects to proceed that would appear to be either at odds with or beyond the scope of the articulated purpose of the act or the description of the project on the ballot. The bond act is intended to build a high-speed rail system, not to stop it. And the authority is working as hard as it can and believes that it can and will comply with the requirements of the Bond Act. But fundamentally, this is a project that the bonds are supposed to get built and not be halted.
All right, thank you. Let's move on to question 4.
So question 4, how much deference should be given to that deference? And I guess my answer is, given that it says that it's in the determination of the authority that financial viability is supposed to be determined, it does give the authority considerable deference. We don't disagree with that. It gives them a fairly high degree of deference. It basically says as long as the high-speed rail authority has some substantial evidence to support its conclusion that it's going to be financially viable, they win. But the problem is that in the situation we have right now, there isn't substantial evidence. They have made determinations that, yeah, this is going to work, but they don't have the evidence to support that. And probably the clearest example of that is basically the actual construction of the iOS South, the first segment that's going to operate as a high-speed rail system, which, by their own acknowledgement, is at least $31 billion. And by their own acknowledgement, they are nowhere close to having $31 billion. They don't even have half of that amount. They don't even have a third of that amount. And to say this is financially viable when you can't even build it, when you don't even know you can build it, when you have no place you can point to and say, we're going to get the money from there. It's to be determined later. And that's not what the voters intended. The voters intended that, no, if you're going to build something, it's got to be financially viable. It's got to be able to be built and to run. And if you can't build it, and you don't know you're going to be able to build it, you shouldn't be starting on it. Because you can't say it's going to be financially viable. How can you say that something's going to be financially viable when, you have something where let's say it's different than the interstate highway system. The interstate highway system, they could say, well, we're going to build it for pieces and we're going to gradually put it all together and then we'll have something. But when you built each of those pieces had independent utility. Each of those pieces was making the entire system better. When you can build something, when you only have $3 billion in federal funds available to you, you can't build anything useful. You can't even build 29 miles. You're going to have, what we're saying they're probably going to end up with is a 130-mile long mound of dirt. And that's not financially viable. And until you can say, we've got money that says we can build this, they don't have something that's financially viable. So that's the first problem. The second problem has to do with saying, we're going to be able to make a profit on this once we get it running. And the problem with that is that there's two parts of that equation. What are the costs and what is the revenue? And the revenue is determined by ridership. And they have done lots of ridership studies, but all of their ridership studies have been on the full Phase 1 system, from Los Angeles to San Francisco. And I think they have actually done some studies looking at the blended system from San Francisco to Los Angeles. But they have never done any studies of what the ridership is going to be when you have just the iOS running from Merced to Burbank. And now you're asking, is that going to run at a profit? The answer is they have no evidence to show that it will. And in fact, when you look at the actual what is available about information about how that's going to work, it would be nonsensical to say it will run at a profit, because it's actually going to take longer to get from San Francisco to Los Angeles or vice versa using that iOS than it will be to drive your car. And it's going to cost more, too. So why would someone take a system that will take longer and cost more and only pay for one person's ride when they could drive their car, have it cost less, have it take less time, and carry 5 or 6 people? To say that you're going to have 2 million passengers is insane. And the only reason why they're doing that, why they can say that, is because they're using a model that was constructed based on the blended system going all the way from Los Angeles to San Francisco. That's not what they're studying. What you're studying is a different, it's apples and oranges, literally almost. You can't compare the two. You have to have information. If you're going to ask about the ridership on the iOS, you have to have the information to show that this is what the ridership is going to be. They have no such information. And finally, the other half of the equation is the costs, essentially operating and maintenance costs, O&M. And there are major elements of O&M that they haven't taken into account. And in addition, they haven't taken into account that O&M that they rely on, the analysis they've done, is based on systems that are running at, say, 160 to 180 miles an hour. And even the International Railway Association pointed out to them, your costs are going to be higher, because when you're running at 220, the maintenance costs are going to be considerably greater, as well as the operating costs, than they are for a train that's running at 180. And there's no escalation of that cost. They don't have any support for basically saying these O&M costs are what the system is really going to do. And in fact, when you compare it to other systems, it's ridiculous. It's laughable, the comparison. Their O&M costs are a third of what other systems of the high-speed rail systems, existing high-speed rail systems, are doing in terms of O&M. So they don't have any again, substantial evidence.
Ms. O'Leary.
The record, we have a voluminous record on the financials, and it shows compliance with the Bond Act. Petitioners are just speculating and basically disagreeing with the authority's own experts. And the authority is entitled to rely on its experts. The operating and maintenance has been subject to searching review, including by the GAO, and all this is in our brief. The ridership and revenue, they have a whole technical advisory panel that has signed off on what they've done. So the authority has worked very hard to get credible numbers, and we believe that we've more than satisfied the standard. My second point is the financial viability is about alignment, and and not some kind of overarching financial viability. There are financial viability requirements that are in 08D, but that's not right yet. That's when the authority has to show where they've got the money to construct. project and how they're going to identify getting that money, and ridership and revenue and operating and maintenance, the components that go into operating subsidies. Those are final funding plan requirements. There is no requirement in 09 that the authority report on or make findings or take evidence on anything there separate and apart from the reporting requirements that are in 2704.08 and in all of the other reports that they provide to the legislature. So the Court of Appeals has said that utmost deference should be given to the authority in its quasi-legislative planning decision. And in connection with the validity part of the case, the court noted that there was no requirement of findings and no requirement of taking evidence. And if the legislature had intended that at this particular point in time the authority had to make all that showing, they would have put it in and put a requirement in, because when the Bond Act passed, the authority didn't have any money to do anything. So they could never have complied with that provision at that time, and that was disclosed to the voters, that the authority was going to have to go out and find matching funds, and the authority has, of course, gotten cap and trade funds and federal funds and is continuing to work on that. But it's simply premature to take elements from the 08D final plan requirements and require that the authority do them in advance of that plan.
So, several things. First off, the requirements in 2704.09 are separate and independent from the requirements in 2704.08. If all was necessary was to do what's required in 2704.08, there would have been no need to add something about financially viable in 2704.09. They would have dropped it out entirely. The fact that they put it in says it's got to have some independent meaning beyond 2704.08. And that meaning is basically saying this is about the system regardless of the use of bond funds. It's still got to be financially viable. You have to be able to show it. And the fact that, this is not the same boilerplate language that was in the validation of the bonds. This is a language that's specific to this act. This is a language the legislature specifically wrote and were invented for this bond act. It's not something that they just pulled out of a box of canned phrases to put in here.
But let me just ask you again. 270409 is fairly specific to the alignment, and it is qualified by to the extent feasible, and then you get to the and shall be financially viable.
Right.
So we are talking about something that's very qualified with extraordinary deference that would seemingly be afforded to the authority.
Well, there are different parts of that that have different qualifications. So it says that the alignment is intended to, in order to reduce the environmental effects and other types of effects, that to the extent feasible, it's to follow existing transportation corridors. And again, that's to be in the authority's determination. And we understand that's an enormous amount of deference. And we are not challenging that part of it. We're not saying, because it didn't exactly follow a transportation corridor here, that it's invalid. No, because again, they said when feasible and in the authority's determination. But financial viability is separate from that part of it. It says, and shall be financially viable in the authority's determination. So it does have deference. It's saying, in the authority's determination, it shall be financially viable. And that's the alignment. So the alignment has to be financially viable. But it doesn't say you've got free reign to do whatever the hell you feel like in terms of financial viability. It's still got to meet that requirement. It's got to be financially viable. Now, admittedly, that's not defined in Prop 1A. There's not a section at the start where you have definitions that it says financially viable means the following. But you have to ask, what did the voters understand when they saw it shall be financially viable?
But isn't that where 08 comes in?
It's part of it, but it's more than that. Because again, like I said, there is the old saying, if you build it, they will come. Well, if you can't build it, they certainly are not going to come. And part of what's involved in the saying it's financially viable is the voters expect it. You got to be able to build it if it's going to be financially viable. If you can't build it, then can't be financially viable. So this is in essence, it overlaps with 2704.08, but it is separate. It's saying you got to show that before you start building something, you've got to be able to show you can build it. And the problem is, this is not, we wouldn't have brought this challenge in 2008 or 2009 or even 2010, because at that point, it wasn't clear exactly what the authority was going to do. And yeah, they weren't planning, we're going to start construction next week, and this is what we're going to do. Now it is. Now they have started construction. Now it is clear what they're doing. And what they're doing is something they can't finish, at least at the moment. They don't have a way of finishing it. And that's not financially viable. And so what we're saying is, until you can show you can build something that you can run, and run successfully, you can't start construction. You're illegally expending public funds to build something that is in violation of the Bond Act.
Is there any final words on this issue?
I would just say that the authority has to show viability before they spend bond funds on construction, and they're not doing that. They're spending funds that the legislature has appropriated and that the legislature has the power to do, subject to its oversight and the reporting requirements that have been imposed by the legislature.
All right, let's go to the last question. I think I know each of your responses, but I'll...
Yeah, they're probably well determined by what we've said so far.
I think they are.
I do have a couple of other comments I wanted to make, and that was the one thing that we didn't talk at all about is the nonstop travel time from San Francisco to Los Angeles.
And before you get there, what I was going to do is finish the 5 questions, take a break, and then I'll let you bring up any issues that either party wishes to present to the court.
That sounds fine. So on the last one, obviously we do believe that because the Bond Act is more than just about the bonds. I was thinking about the appropriate analogy, and maybe one analogy that came to my mind was when you go and apply for a mortgage, and you're essentially getting a loan. And yeah, a lot of the terms in the mortgage have to do with the terms about how much you're going to pay and when it's due and what the payments are going to be and so forth. But there are also parts of the mortgage that are very different than that. So, for example, a mortgage, depending on how much of a mortgage you're taking out, may require private mortgage insurance. And if you don't get private mortgage insurance, then you haven't satisfied the terms as well. If a mortgage usually requires that you have homeowners insurance. And if you didn't get homeowners insurance, you're violating the mortgage. So there are contracts that are in some ways analogous to this that do go beyond just saying, we're going to give you the money and this is how you're going to pay it back and this is what you're going to do with the money. There are contracts involving money that specify other things beyond just how much money you're getting and when you're going to pay it back. And this is one of those types of a contract. It's a contract that covers the bond funds, but it covers far more than the bond funds. And it covers, in fact, it really puts limitations on what the Public Utilities Code section initially said the authority could do. The legislature proposed to the voters, and the voters approved, saying, we're going to restrict somewhat what we generally agreed to because of the fact that we're going to provide some public funding for it. And those restrictions are there, and they apply, and they go beyond just the bond funds. They go to any sort of funds that the authority is using to build a system. The system has to comply with the bond measure, and if it's not complying with the bond measure, it doesn't matter what the source of funds is, you can't do it.
What I hear you arguing, if I was going to summarize it and utilize your analogy, is essentially the act is the appraisal. And you've got an appraisal for a piece of property. The property's been described, and it has all the conditions of description. And then you're getting a loan on that piece of property which has been so described. And the loan basically is for that piece of property. Is that what I'm hearing?
In some ways, I'm not sure the analogy is exactly the same, but in some ways it's basically saying, here's what we're giving you this money for. But you see, the point is that as with a mortgage, it can put conditions on it beyond just, this is what you've got to do with this money. It's basically got to say, for example, you've got to put insurance on, you've got to put homeowners insurance on what's on this property. You've got to do this and you've got to do that. Things that go beyond just what happens with the money that you're getting loaned. And I think that's the same that's true here. And the other difference between this and a mortgage is, of course, if you default on the mortgage, they can come in and take your house back. If you default on a bond measure, I mean, not default, but if you basically violate the provisions of the bond measure, the only recourse is to go into court and say, you can't do that.
Ms. O'Grady?
I discussed this earlier, and it's in our brief at page 29 to 31, but I just want to make a couple quick points. We believe this was resolved in the Court of Appeal decision and your decision, where the court held that Prop 1A does not restrict the legislature's plenary powers to appropriate funds for high-speed rail. That any restriction on that appropriation power has to be expressed and unambiguous, and there is nothing in the Bond Act that speaks to that.
All right. Let's take a break for 15 minutes, and then I'll let the parties present any additional information they think would be of use to the court.